Good afternoon. Thank you for the participants who have already joined our talk, and thank you very much for Dr. Jack Rozel, who will be giving our talk today on making sense of Maas, understanding the expanded duty to warn in Pennsylvania. So as an introduction, Dr. Rozel started his experience in emergency mental health as a suicide hotline volunteer more than 30 years ago. Over his career, he has worked locally and nationally to improve crisis services for patients and communities, and has been involved in a number of efforts to improve the interface between the legal and mental health systems. He has been the medical director of the Resolve Crisis Services of UPMC, Western Psychiatric Hospital, since 2010, and is the president of the American Association for Emergency Psychiatry. Reflecting his interest in bridging systems and programs for addressing complex social programs, he works extensively on issues related to violence and firearm injury prevention in a variety of settings. He is an associate professor of psychiatry and adjunct professor of law at the University of Pittsburgh. He has been named a distinguished fellow of the American Psychiatric Association, the Behavioral Health Professional of the Year by Crisis Intervention Team International, and as an exemplary psychiatrist of the year by the National Alliance for Mental Illness. Dr. Rozel is, as a last point, Dr. Rozel tweets at @ViolenceWonks, along with his fellow forensic psychiatrist, Dr. Layla Solomon, where the pinned tweet reads, "We dwell in dark places, so you don't have to." And that pretty much sums him up. So thank you, Dr. Rozel, and we look forward to hearing from you.
All right, we're handing over the microphone here. All right, so for all the folks online, and I see we have not a bad number of folks online, thank you so much for joining us. And we have a handful of folks here in the auditorium with us. So we're gonna talk about a case called Maas versus UPMC today, which is a new case here in Pennsylvania that really establishes what duties to third parties may look like going forward. The opinion came out this summer, and the timing of it I thought was interesting because it came out in the last week of July, which was right around a significant anniversary. And just to give you some timing to it, in the fall of 2011, a young man went to Aurora, Colorado to go to graduate school. And he struggled in school. He ended up at the counseling center, and he disclosed dark fantasies, right? So if life has any meaning and I take that life, then that's something powerful for me. But never expressed specific intent, never identified a target, and would go into these sessions with the therapist and later with the psychiatrist. They no, I'd never actually do anything, but they had concerns. They got second opinions. They did formalized risk assessments.
Jack, you're muted. We can't hear you.
Okay. All right. He'd scout out different locations through the spring to decide where he wanted to be to do this attack, how far from the police, how far from hospitals. And he'd go into the therapy session and say, I'm not planning on doing anything. He struggles terribly in school. He actually ends up failing his exams. On the day he gets the results, the treatment team reaches out and says, even though you're gonna have to leave the program, we are very happy to continue to treat you because we want you to be well. And he turns that down and he goes and buys an AR-15 rifle. He buys steel core ammunition, knowing that he's chosen a specific movie theater that has steel seats, and that if he doesn't have good ammunition, he won't be able to penetrate the seats to kill as many people as he wanted. And at the end of that month, he went into a movie theater at a midnight showing of a Batman movie, and he opened fire. 12 killed, 58 wounded, 12 more with other injuries fleeing the attack. After months of planning and preparation, after treatment with a really outstanding treatment team that was thorough, that consulted, that got second opinions, nonetheless, they encountered fairly significant, terrible and tragic outcomes. So, with that, we then went on to the Maas case, and we'll talk about the Maas case. Now, for the purpose of disclosures, let's see, all right. For the purpose of disclosures, I have no pharma conflicts. I do a lot of stuff around violence. And to be very clear, while I am This is the microphone right here. Don't worry. Lauren, this is the mic. Yep. So I have no commercial conflicts of interest. And I'll say that while I am in UPMC, while I am of UPMC, I'm not speaking on behalf or for UPMC. Related to this, while I have been to law school, while I teach at a law school, I am not a lawyer. And more importantly, I am not your lawyer. And the one thing that I promise your attorney will always agree on is they want legal advice coming from them and not from me. That said, like I said, I'm a law professor. And we like tricky, messy cases that make us think, that make us scratch our heads. So with that, buckle up, because we've got a couple cases here. All right, we'll begin at the end, right? The takeaway points. In Pennsylvania, mental health professionals have a duty to warn in certain circumstances, including specifically identified individuals, readily identifiable individuals, and now under the Maas ruling, we have a duty to warn entire groups of people, or of that group may be a target of severe violence, and we can't identify which specific member of that group he is or she is. The threshold nominally is specific and immediate threat. We'll talk about what that actually means. The degree is serious bodily harm. I have still quite a few questions about how we deliver those warnings. And the best tools to deal with this are second opinions and consultations and engaging with risk management and legal teams at your institution. All right. So now we go back to the beginning, right? We're mental health professionals. One of the things we're really good at is providing a safe space for our patients, for our clients to come in and vent, say, oh, this is so stressful. Like, I don't like work, I don't like family, I'm angry, I'm having these thoughts, and we give them a safe space to vent, right? That's part of what we do. And we don't, freak out with every sort of dark fantasy that they might share with us. But here's the thing, right? Even though we provide that safe space, we also know, according to a number of studies, that as many as 80% of attacks, whether it's one person going after one other person or someone engaging in a major attack, are preceded by what we call threats, okay? So a threat would be, Jamie, I'm gonna get you. Don't worry, Jamie, I'm not gonna get you, okay? Versus leakage, Jamie, I'm gonna get Ken, okay? And in that case, now Jamie's like in the hot spot, because Jamie's that bystander, we want to be an upstander, we want to engage them, help Jamie petition that 302. And a lot of attacks are preceded by that threat or that leakage. But by the way, according to some studies, maybe only 20% of these attacks are preceded by that. But it's a dot. It's a really important dot, because one of our mantras in threat work, you got to collect the dots before you can connect the dots. Now, by the way, you also have to have someone who says, hey, identify this, it's a dot, we got to do something with it. But here's the thing, threats are one dot. They are one part of risk. They are one part of the broader picture. They are not the only dot, and they are neither necessary nor sufficient in and of themselves. So we got to pay a lot of attention to it, but it's maybe not an absolute thing. Now, next, duties to third parties, right? Sometimes it gets kind of fuzzy, and we've got to use judgment, right? Someone comes in and says, gosh, I get lost in these dark fantasies. I'm so hopeless. I drive around, and sometimes I think, I'll let go of the wheel, right? And just see what happens. Do you have a duty? Do you have a duty to warn people? Who would you warn? How would you do that? Kind of hard to know. Say, I don't really know if I do it, but maybe I would, and right? Here's the thing, duties are gonna vary by jurisdiction. By the way, if anyone's logged in from outside of Pennsylvania, these rules may not apply to you. It varies by profession. The duty of a lawyer may not be the same as the duty as a mental health professional. And frankly, social context. What was the last bad outcome that's simmering around in our heads? What's the risk tolerance of the chain of command that we operate at, right? Well, now let's sort of shift the scenario, right? Again, I feel hopeless. I might just let go of the wheel. I don't think I'd really do it, but sometimes you decide, what if I did? With that stem, do you feel like you got to do something, right? How about if they're an Uber driver? How about if they're a school bus driver? How about if they're a commercial airline pilot? Have you changed your mind about whether or not you'd do something? You'd warn, you'd intervene, you'd do something else, right? It's not always clear cut. One of the important things that we work with a lot as a forensic psychiatrist is this idea of, we call it the hindsight fallacy, or post hoc ergo propter hoc fallacy. After this, therefore because of this, right? Correlation is not causation. We have a couple neat studies that back this up, and basically if you tell a bunch of folks, hey, you know what, there's this sequence of events and a bunch of doctors did this evaluation, they didn't see any risk factors, and then there's a bad outcome. Are the doctors responsible? Versus you take another sample of folks and you say, hey, guess what? There's a bad event, X killed Y. Prior to this, a whole bunch of doctors did independent evaluations. They didn't really see any risk factors. Were the doctors negligent? And what happens is most respondents are actually more likely to attribute blame in the second scenario because they've been primed with the bad outcome. This is a human cognitive error. It's very common. It happens with physicians. It happens with lawyers. I would suggest that it happens in judges. It happens in Supreme Court justices, as may come out in the Maas case, right? A couple basic concepts. I know we have some legal people around, but we also have a lot of clinicians. Some things I really want you to just understand about how the legal system works. If I run a red light and I'm in front of the magistrate, they're going to bang the gavel. They're going to say, you know, guilty or not guilty. It's sort of a up, down, yes, no. It's kind of like you get the lab result, right? Pregnant, not pregnant. There's not a lot of ambiguity. If there's a dispute about that outcome, it might get appealed. And as something goes to an appellate court or Supreme Court, thumbs up, thumbs down. It can be a written opinion. Some of these are quite long. In Tarasoff, it was an 18,000 word opinion. All right, it's kind of like journal club. There's a lot of nuance. There's a lot of debate. What does it really mean? Is what they argue, does it really add up? Okay. Also, an important concept of how the legal system works and how courts are supposed to work is stare decisis. The decision stands. So if our state Supreme Court makes a decision and a similar case comes up, all the lower courts should say, hey, look, we're going to apply these rules, right? If the US Supreme Court makes a decision, all the lower courts are supposed to sort of fall in line under that. Court opinions should restrict themselves to the facts at hand. So if it's a court case about issues A, B, and C, and there's an appellate opinion, they should talk about the facts of A, B, and C. It'd be really interesting. And E might be a great example that's related to it, but they shouldn't be talking about that. Yet in a couple of these cases, they do. And by the way, if it's a malpractice case and I'm getting sued, it's up to the people suing me to show more likely than not by a preponderance of the evidence that I screwed up and that a harm resulted, okay? All right, a couple more basic concepts. In these cases, we talk a lot about duties to third parties, about duties to warn or protect. Well, a couple important things to know. Duty says I am legally obligated to act in a certain way towards you, and it also implies that you have a right for me to behave in a certain way, okay? So if I fail in that and there's a harm that results, then what happens is, you know, there may be commensable damages, okay? There's the idea of permission. So some states say there's a duty to warn, some states say there's permission to warn. So if you violate confidentiality to warn someone, you're not gonna get, you know, slapped for the confidentiality violation because that state said you have permission to warn. There's a lot of ambiguity about protect versus warn. They're closely entwined and sometimes confusing concepts, and often scholars and judges and certainly practitioners find it easy to confuse them. And operationally, it's not clear, at least to me, which one is always easier to execute or which one sort of is the greater or lesser duty of the two. Now, if we spend the next hour talking about the Heimlich maneuver, and we all become, you know, world experts in giving the Heimlich maneuver, and then we violate, you know, the social distancing, and we all go out to a restaurant together, and we look down the counter at the diner, and we see someone choking, and say, that person is choking. That's what the Heimlich maneuver is for. And we can go back and finish our, you know, our sandwich. And it's really cold-hearted, but that's completely legal, right? We have no duty to help people in distress except for a few certain circumstances. If we put them in harm's way, if we announce that we were going to assist, so we see someone choking and say, that's what the Heimlich maneuver is for, I'll take care of it, and everyone else is reassured, and then say, ooh, time to update Instagram, right? Or we have a special relationship. Clearly, we have a special relationship to our patients and those who present to care, for care at our facilities. We also, in some specific narrow circumstances, have a duty to those who are harmed or potentially harmed by our patients. And that is important to know. That is, we're sort of talking about exceptions to exceptions to exceptions. It's a very nuanced area of law and policy. Now, when I go to my therapist and we communicate, that therapeutic communication, I expect to be treated confidentially. And in fact, by law, it's privileged. It's my right as a patient not to have that information shared in ways that are against my interests and the court of law without my permission. But again, this is certain communications and certain relationships, right? If a patient comes to me and even though it's a therapeutic communication, they threaten to kill me, that's not actually privileged, okay? So it's only certain communications within certain relationships. All of this idea of privilege began with attorney-client privilege, okay? Now there are a bunch of exceptions again. if I give consent to my therapist to share the information, observations of certain types of injuries, probably certainly everyone in the room and probably most of the people on the call are mandated child abuse reporters. In some states, there might also be an elder abuse reporting requirement, not in Pennsylvania, but in others. HIPAA, I hate HIPAA, but HIPAA actually has a lot of different ways to share information. And oh yeah, by the way, amongst all these different exceptions are violations sometimes to protect the life and safety of third parties, which is what we'll be talking about. Our tools for this are limited, right? We have the Mental Health Procedures Act, which is like 45 years old. It was enacted in 1976. It occurred to me as I was driving in today listening to sort of the pundits talk about the upcoming election that we hadn't even had the election that put Jimmy Carter in office when this law was enacted, just to give you an idea of the time frame here. And you know what? For a 45-year-old law dealing with human rights and neuroscience and everything else, it's held up reasonably well, but it still was never designed or engineered to do these tricky duties to third parties. We have HIPAA, we have high tech, we have the CFR regulations about substance use information. We have new issues coming up with the Cures Act that we're just getting ready to enact now. Educational information under FERPA, CRE information, which is criminal history information, and all sorts of other variations there. So we've had a lot of, none of which were specifically designed to answer the question, what do I do when my patient says at 8 o'clock in the evening that they want to go kill their landlord, their neighbor, their brother, right? What do I do with that information? Well, in Pennsylvania, we don't have a statute, so we have case law. And as Rick Kidwell says, you know, bad facts make for bad law. No one goes to live unless it's tricky, right? The cases that get to the appellate or Supreme Court level, they are messy, right? They are potentially complex cases. The slam dunkers get settled or dealt with or dismissed earlier, right? And Oliver Wendell Holmes talks about this idea that like the great cases actually end up making bad law. The stuff in the law school world we talk about as being landmark cases are really exceptional fact patterns, exceptional cases, which boils down to the fact that when you read into these cases, they've got a lot of what I'd call whiskey tango foxtrot moments, okay? Where you just are really left scratching your head. All right. The young lady on the screen now, her name's Tatiana Tarasoff. She came from an interesting cosmopolitan background. Parents Russian, she was born in China, raised mostly in South America. And in the fall of 1968, her family relocated to the Berkeley area. School year, she went to a party at the International House. And there she met a young man, and he was smitten by her. She was beautiful, she was charming, she had this incredible background. And he had sort of a really remarkable trajectory himself. He came from the Dalit, or the untouchable caste in India. He was born in a town that when he was growing up didn't have electricity or running water at first. And he made the trajectory to get to graduate school at UC Berkeley in the 1960s. So he had something noteworthy about him as well. Now, he was smitten by her, she was uninterested, the fall goes on, he pursues, she's again disinterested. By happenstance, on New Year's Eve, they end up at a party together, not by intent. And as the clock strikes 12, he says, Tanya, can't I have just one kiss? And she says, yes, one kiss on my cheek. And he says, we're praying together, we should be married. He said, oh, hell no, right? And in the coming weeks, he says, we should be married. And he gave her a betrothal gift. She burned the betrothal gift and returned the ashes, right? This was not like a subtle friend zoning kind of thing. This was an unambiguous no. If there's any part of this guy that was wired to understand no, we would have never heard about this case, right? Spring progresses and he's obsessed and fixated and his life is sort of falling apart, and he's following her around campus with a tape recorder saying, Tanya, just explain why you won't be with me. His academic work deteriorates, his lab mates are concerned, they send him to the student counseling office. And over the summer in one of his therapy sessions in August, he tells his therapist, my life would have been perfect if we'd been together, but she spurned me and and I'm going to kill her. And he says, wait, like you're thinking about killing her, you're fantasizing, or you're really going to do it? And he says, I'm really going to do it. And he says, aha, y'all need to go to the hospital. Did the California 1960s version of a 302 to try and get him to the hospital. Allegedly, he typed up a letter to the police and says, hey, you're going to, and he's going to present really well. He's going to seem organized and intelligent and insightful. Trust me, I'm the psychologist. He's really ill. He needs to go to the hospital. Campus police pick him up. They talk to him. They say, he seems kind of with it. He has good insight. well, we're just going to let him go. Therapist finds out about this. He goes, ah! And he does what we're supposed to do when something like that. We go to our boss and say, boss, what do we do? And the boss says, you did what? You are a bad therapist. You let your countertransference get out of control. Destroy the records of what you just did. By the way, pro tip, never destroy a medical record. And then they abandoned the case. They said, don't have anything more to do, because clearly your countertransference is that you hate your own patient and you're a bad therapist because of that. Well, it turns out she was actually out of the country at the time. When she came back into the country 2 months later, he knew about this because he's now with her brother, right? Said there's some weird twists in these cases. And he goes to the house, knocks on the door. Mom intercepts and says, scram, loser, stay away from my daughter, or words to that effect. He leaves. He comes back a few hours later. This is a Saturday, late afternoon, early evening. Mom had gone grocery shopping, and now he's got a knife and a gun. And he gets in the house. He attacks her. He chases her out to the lawn, stabs and shoots her to death, and actually calls the police himself and said, she ruined my life. She deserved to die. Not unsurprisingly, he faces criminal charges for homicide, puts up a defense of the equivalent of not guilty by reason of insanity. And at that point, they have the therapist come in with the records. And at that point, the family says, what? You knew our daughter was in danger and you did nothing? How dare you? And then they sued the therapist, the university, the police, all sorts of other different folks, okay? And from that civil lawsuit for malpractice is where we get the Tarasoff standards. Now, by the way, there were actually 2 California Supreme Court cases on the Tarasoff on the civil side. We pay attention to the second one, the superseding one. And in that one, the court said that a mental health provider, when they know that someone is, in these certain criteria, right? They've got to take reasonable steps to protect, not warn, but to protect identified third parties from foreseeable and serious harm. Now, what does reasonable steps mean? They sort of say, you know what, reasonable steps can be a lot of things. It might include warning. It might even include notifying the police. But there's no actual duty to warn, but it may be one reasonable step. For identifiability, Tanya Tarasoff was the known target. In fact, the assailant had told the campus police who it was very specifically. The court case doesn't really dwell into what they meant by identifiable here. Foreseeability, the court talks about it has to be with reasonable judgment, knowledge, and skill of similar professionals, sort of the usual reasonable professional standard. Here, serious harm, this idea that homicide is the known intent. And at the time, by the way, people said, oh, this will be the death of psychotherapy. And I have, by the way, no good data on how much psychotherapy we're doing in 2020 versus 1976, but I'm fairly confident psychotherapy did not die. Okay. All right. Now, there are so many things with this case that drive me nuts that I like to torture my law students with. It was a really complex cross-cultural case. These were 2 folks from very unusual, diverse backgrounds, treated by a cis white male therapist who was very good, but in an era when a lot of cross-cultural psychiatry and mental health was, why can't you be more white male and upper class like me? Not always a great solution. Was it a relationship? Not exactly, but it has that sort of stalking DV flair to it. There were questions about duties of law enforcement, destruction of records. In the criminal case, which also had an appeal about instructions to the jury, the trial judge ultimately said, I'm tired of hearing about this case. If you leave the country and never return, banishment for premeditated homicide, right? Lots of weird things about this case. A few years later, a federal circuit court in Nebraska, dealing with the case of a VA patient who was in partial hospital, talked about thoughts about going to a bar and shooting a bunch of people, then left AMA, and over a period of 6 weeks acquired a shotgun from a Sears store, hence the Lipari v. Sears titling of the case. Ultimately went in and shot up this bar. And here the court says that when there's reasonably foreseen that there's an unreasonable risk of harm to the Liparis or a class of persons of which they were members, then duties apply. And here they're basically saying, yes, in fact, it's not just duties to individuals. If it's sort of reasonably foreseeable that it's a group of people, that can be considered as well. But again, that's a Nebraska case. Tarasoff is a California case. We don't have a Supreme Court case. We don't have a federal statute that came out of Congress. We don't have a state statute that came out of Harrisburg for us. And our codes of ethics are kind of vague, but mostly come down along the lines of you have permission to warn, okay? Now, why do the state ethics standards matter? They matter because of HIPAA. Now, HIPAA was really well designed. If I'm stupid enough to say, put the next 10,000 folks who come through Rozel, put their names, their social security numbers, and their diagnoses on an unencrypted thumb drive or to share it in like a Google document or something dreadful like that. That's what HIPAA is about. HIPAA is not about it's 2 in the morning and this person is in the wind and they're saying so-and-so. It was just never designed to work at that small scale. And the metaphor, it's like you're trying to prune a rose bush or a bonsai tree with an excavator, right? It's a great tool for other stuff, but not for the task at hand. To reassure us, in January of 2013, a month after Newtown, 2 months after the Aurora, Colorado shooting, the Office of Civil Rights for HHS, which by the way are the people who enforce HIPAA violations, came out and said, hey, we know regulations are really tricky and tough to read. They are. But what we're really saying is that you're allowed to warn either the target or anyone who might reasonably help if you think that that's what's necessary and appropriate to prevent serious harm to them or someone else, as long as it's in good faith, as long as it's in alignment with professional ethics or your regional jurisdictional standards, okay? So HIPAA is permission to warn. All right. Now, by the way, this is all about future harm, okay? In Pennsylvania, the only sort of retrospective bad thing we have to report is child abuse, okay? I go into my therapist and say, oh, I feel so good now that I killed blah, 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 right? That may be criteria for 302, but they can't actually, that was child abuse, right? They've got a lot of countertransference to deal with, but they can't actually do anything with that. All right, let's get local, let's get granular, let's get back to the Commonwealth of Pennsylvania here. All right, 1990, 2 people, one of whom had schizophreniform disorder, were working at a food service place, and there was a conflict between them, and the guy strangled the woman. In fact, they had had a relationship, they were living together, and in a lawsuit that included the employer as well as the treatment team, it was argued that in fact they all had these duties to protect this woman. And here our Superior Court, not our Supreme Court, so our Intermediate Appellate Court, said, we're not going to create a duty for non-identifiable and arguably non-foreseeable third-party victims, okay? Just because they are living together and just because she would have been the most likely target of violence doesn't mean that there was a duty for the treatment team or anyone else to protect her. All right, so that's 1990. A few years later, another Superior Court case that was appealed to the Supreme Court that and cert was denied, again, sort of talks about this idea of a guy who'd been hospitalized for suicidality, is discharged and had a known propensity toward violence, had a history of severe domestic violence, kills his wife about a month after discharge. And again, the court's coming back and saying, foreseeability really matters. And there's got to be specific identity and specific threat, even in the context of someone with violent propensities, even in the context of a known ongoing hostile relationship. Said, listen, that's just not enough to create a duty. So you hear the court sort of saying, hey, let's be really careful about creating new duties. All right. Now, we have the Hausler case, a very tragic case about a young lady in Philadelphia by the name of Teresa Hausler. Fell under the sway of this super who was actually a real SOB and had priors for violent offenses and robbery and things like that. But he was charming, and she fell for him, and they moved in together. And unsurprisingly, things became violent. They started in couples counseling at the Philadelphia Center for I think, human something treatment, and pretty quickly realized, you know what, they're going to split up. The therapist says, hey, you know what? I can't really keep treating both of you if you're splitting up, even though that's probably the right thing for you to do. I'm happy to refer you each on to other therapists. The wait list at our clinic is only like 6 weeks. I could continue treating you in parallel, but it might be a little ethically complex. And the therapist actually documented all of this really nicely. And said, you know what, it might be a little awkward, but we want to continue in parallel therapy. Well, she moves out, and he still has sort of, I'm going to kill her, and I'm not really going to kill her. So he thinks about it, retracts it. On a Friday morning, the therapist comes in, and there's a voicemail from the guy saying, hey, she's coming to get her stuff, and I'm going to kill her. The therapist says, I've got an opening today at 11 a.m. When is there ever an opening at 11 a.m., right? And he comes in, spends about an hour, and if there's a line that's 302 criteria, he dances almost to that line and doesn't quite cross it, and then sort of dances back. And at the end of the session, the therapist says, I'm really concerned. I want you to go to the ER. And says, nah, I don't think I need to do that. And I'm really not going to, do anything to hurt her, right? Therapist is concerned. He's walking up and down the hall of his clinic talking to his colleagues. I'm concerned, what do I do? Do I warn? Do I do something else? And again, we've got good documentation that this occurred. And at 12:30, the receptionist says, I've got a call from Miss Hausler. Do you want me to put it into your voicemail? And he says, no, I want to talk to her directly, and says, whatever you do, don't go back to the apartment. It could be really dangerous for you. Please don't go. All right? I'm concerned that your ex-boyfriend could be really dangerous, right? She says, okay, I'll think about that. 12:45, he calls back and says, I killed her. Shot her 5 times. She bled to death in the stairwell of the apartment building. He's still in state prison. In the civil case that the family brought against the treatment center, they broached the question of, what's the duty here, right? And we get the Emerich case, and it's Emerich because it was actually brought by her stepdad. Tragically, this family lost both of their children to gun violence. And one thing that the court case does well is they say this is a duty for mental health professionals. It's not just, healthcare professionals in general. It's not for lawyers. It's for mental health professionals. And they start with this sort of STEM idea. A mental health care professional, under certain limited circumstances, owes a duty to warn third parties of threats of harm against that third party. Right? That's where it begins. It seems simple, right? Excuse me, I'm gonna take a sip. All right. Well, this is a 12,000 word opinion. There's a lot of nuance in here. What kind of threats? They talk about threats of harm and potential harm. And if you know me, I could spend a day talking about what that might mean. At one point, they use the phrase immediate, known, and serious risk of potentially serious harm. All right? And I think that sort of really nicely captures a lot of what they're going for. On 3 occasions, they talk about serious bodily injury, which by the way has sort of a certain criminal justice meaning to it. And 3 times they talk about a specific and immediate threat. So it's not that I pose a threat, but I have made a threat, right? It's specific and it's immediate. Who do we warn, right? Now, in Tarasoff, they knew the target, right? In Emerich, they knew exactly, the therapist knew who she was, knew her phone number, knew her date of birth, probably knew her social security number, knew about what kind of pet she had as a kid, right? The target was known, the target was warned. All the court needed to talk about were duties to specifically identified potential targets. And they did talk about particular individual or specific identity. And then 7 times in the majority opinion, they used the phrase specifically identified or readily identifiable victim, all right? And that embellishment, that painting outside of the lines, that dicta is something that's now hanging over us more than 20 years later. They go on, they say, listen, this idea, we're saying there's a duty to warn and that you're protecting by warning, and it's met with virtually universal approval. And then they cite like 16, 17 cases from across the country that they say backs up what their argument is. Well, when you go back and actually read those cases, what you find is that mostly they don't really support the court's contention, right? So when you have that college professor who checks your footnotes or that reviewer too who checks your footnotes in the manuscript submission, well, guess what? So there's one case that talks about a duty to warn for personal harm. 6 of them talk about duties to protect. A couple of them say there's no duties to warn or protect. One of them said, hey, in this case, there wasn't even a threat, so of course there couldn't be a duty. One of them, the Lipari case, talks about warning a class of people. One of them is a duty to protect a barn, which actually is one of the better written cases in the canon. 2 of them are about a duty for dangerous driving. He shot her, he didn't hit her with a car. One of them says there's no duty for dangerous driving, thanks, I guess. One's about, reasonable care, whatever that's supposed to mean. One of them said there's a duty to report child abuse. This wasn't child abuse. Right? It's a really tricky case to interpret. And here's the thing, right? When we come to the actual court opinion, it was a 6-court, or I should say a 6-justice panel that heard the case. I think someone had just retired and there had been a reappointment. And what you have is you have Justice Cappy writing for the majority. Flaherty concurred. Now for you non-legal people, that basically means I agree with your final rule, but I think your logic is flawed and I would have thought it through differently. Justices Apala and Castillo joined in another opinion where it said, again, we agree with some of your findings. We don't actually agree with all of that. That's concurred and dissented. Justice Nigro wrote his own concurring and dissenting opinion, and Justice Newman also wrote her own concurring and dissenting opinion. I certainly haven't gone through the whole canon of the Pennsylvania Supreme Court, but I can tell you in my experience, that is the most divided, the most pluralistic opinion I've seen out of our state Supreme Court. And it makes it really hard to know what to do. As we've heard all the debate over the past weeks about the confirmation hearings of Justice Baer, the idea of the impact of a 5-4 or a 6-3 court, that's kind of what we're talking about. Like, what's the box score going to be? And here, it wasn't like as easy as saying it was like a 5-1 or a 4-2 decision. It was a very subdivided opinion. It's hard to know what the rule is to take from that. Well, helpfully, OMSA steps in to clarify. And they said a couple things, like there's the duty to warn or otherwise protect third parties, although that's not actually what the court opinion said in this bulletin, but that's what the bulletin says. They said there's a possibility that the duty to protect might sometimes be discharged by means other than warning their target, which might mean commitment, even though and acknowledging that the Emerich case didn't actually discuss anything like that. The Emerich case said there's a duty to warn, right? They did emphasize the idea of specific and immediate threat, and then basically they all sort of boiled it down that everyone should discuss it with their lawyers, which is, I think, actually ultimately all they really needed to say, although it doesn't really add a lot of clarity to the situation. Two years later, or a few years after that, in another state case, an FDP v. Ferrara, and this was a case where someone was in a group home, went with their guardian for sort of a weekend pass. The guardian left this person with their own father, who was a little bit elderly, a little bit infirm, and the guy sort of went out into the neighborhood and raped a child. And as a result of this, they sued, and basically the court came back and said, listen, if we allow recovery against mental health and mental retardation providers for harm caused by their patients, except in the clearest of circumstances, would paralyze a sector of society that needs to perform a valuable service to those in need of mental health care. All right, so just to review a little bit here, right? They're saying that they don't want to expand the duty capriciously. Dunkel says limitation of duties and a high threshold for identifiability. Leonard says foreseeable attack on a specifically identified individual, right? Emerich talks about a simple warning being sufficient and duties should be limited. The FDP case says don't extend the duty capriciously or carelessly. The Maas case says hold my beer, because here we go, right? Well, it's another heartbreaking, tragic case. This young lady is Lisa Maas. She grew up in Erie. She came to Pittsburgh to go to school. She came to go to the Cordon Bleu Culinary School that was downtown back about 12, 13 years ago. She arrived in the fall of 2007, and she moved into an apartment building. And a few months later, in January, a young man moved in down the hall from her. And this guy had actually been discharged from Mayview State Hospital. He had diagnoses of antisocial and paranoid personality disorder. To be really clear, antisocial personality disorder and paranoid personality disorder, not paranoid schizophrenia, paranoid personality disorder. Arguably an unusual pairing of diagnoses for someone to be in a state hospital, and arguably a really bad basis for a referral to CTT. Okay, this is like not who should be going to a CTT program, but that's of course who we ended up with. And he was in a personal care home through the fall, and in January of 2008 moves into this apartment building, and he doesn't like it. And he complains to a team, and every once in a while he'll go to the hospital and he'll mutter something about I might kill someone. And over the course of about 4 months, even though on most of the encounters he doesn't actually talk about being homicidal, but at different times he says, yeah, you know, I'm gonna kill someone, right? He talks about, I'll kill a neighbor. I'll kill someone who pisses me off. People on the street, my friends. Not sure how many friends this person had, to be clear. He'll kill his brother. I've never actually been able to confirm whether or not he has a brother. I've done some digging on that. I'll kill anybody, right? At one point he says, I will kill anybody. But he also, at one point he says, I'll kill a male neighbor. At one point he says, I will kill a next door neighbor. And in May of 2008, a day after being discharged from a DEC evaluation, and he's back in his apartment, and on the Monday evening, his CTT worker calls him and says, how you doing? And they check in, and he denies an EHI. And a couple hours after that, he takes a pair of scissors and he stabs Lisa Maas to death. Neighbors call the police. They hear the screaming and the crying. Police arrive, take him into custody fairly quickly. I had the chance to speak with one of the detectives who was involved in this case, and he said that as he approached the scene of crime, as he approached the defendant, the guy sort of made eye contact, seemed to appreciate, hey, it's the guy in the suit, it's the guy with the brass band, and says, I killed her, and it's all because of that gendered epithet, tagging out the psychiatrist, Dr. Barwell, who's the treating doc with CTT, all right? This is Hampshire Hall. It's on Center Avenue, just a few miles from here. I drove by it on the way here. It is 4 floors, 10 units per floor. And they were on the 4th floor. The assailant had a corner apartment. She was 5 doors down. So not the next door neighbor, but 5 door down neighbor. From an overhead view, this is Hampshire Hall. Everything highlighted in blue is an apartment building or other residential type of place, okay? There's no shortage of what a neighbor might be. And by the way, this is, you know, a couple miles as the crow flies from where Mr. Rogers was filmed, right? We have a broad definition of what it is to be a neighbor here in Pittsburgh, or at least I would argue that. And so the question of the threat to kill a neighbor, what exactly does that mean? And that's what was at the heart of this case. The family sued and said, you should have done more to protect our daughter. There was a motion to dismiss saying, listen, you have not actually alleged facts that meet up to the Emerich standard. And in fact, the court ultimately said, you know what, we think there is, and it got appealed, and it's ultimately over about 10 or 12 years been appealed all the way up to the state Supreme Court. And as the Supreme Court says, we will review this case, they identify what the issue is that they're gonna review. And here they said, for all the issues that are in this case, what they're really gonna review is this idea of how do we define an identifiable third party? How do we define this idea of, can it be one member of a group? Can it be an entire group? How do we parse out this math? Well, let's think about that, right? So a target that might be a member of a group versus a number of people within a group, right? So the college student says, I'm gonna kill somebody in my chemistry class, right? Maybe they've already decided it's gonna be Dave who knocked over the test tube in lab, and that's the one who's gonna be, but they're just not gonna tell their therapist who the target is. Maybe they haven't decided who it is, but they hate chemistry in general, and so someone's gonna bear the brunt of this. Maybe they wanna kill a lot of folks, right? Who do you warn? Do you warn the entire class? If you can't identify the individual, and that's sort of what the question is here, right? And by the way, do we now go and say, hey, listen, Jack, hey, chemistry 201 class, Jack is in your class, and he wants to kill one of you. We don't really know who it is, but he wants to kill one of you, so good luck with that. Carry on, right? That's kind of tough. All right. Now, in court proceedings, what happens when something gets appealed to the Supreme Court is each side puts in briefs. So basically, sort of another term paper assignment where they say, these are all the arguments we intend to make, and this is the legal backing, blah, blah, blah. In the plaintiff's brief, this is the lawyers suing on behalf of the family. One of the first things they say is that the fact that Barwell could ask about homicidality and not believe there was imminent risk is patently false, okay? The fact that Dr. Barwell documented things like denied clearly meant that she was concerned about imminent dangerousness or homicidality, okay? This is literally the standard care, okay? If you're like doing a live in psychiatry and you don't ask about HI, is like a core element of the standard of care, and yet they're saying, nope, patently false, all right? Like I said, there's some whiskey tango foxtrot moments. They go on to say that because the assailant had a ret payee, okay, a financial guardian, that the defense's contention that he was a voluntary patient was simply absurd. Now, that's significant because the law, when it comes to duties of controlling the behavior of a patient, a lot of the standards that are out there talking about sort of different thresholds based on whether or not they're a voluntary or an involuntary patient, things like that. In the language of the Pennsylvania statutes for commitment, they clearly say this is not about financial guardianship. And the language of the state laws around guardianship, they clearly say this is not about medical decision making. The laws clearly say these are two separate and different things. We have a number of case law on this as well. My first year law students hopefully know this. Certainly my third year students do, right? And yet here they are saying, listen, it'd be absurd to think that this was a voluntary patient. And then they close with saying that the practicality of warning the assailant's neighbors is not relevant. In fact, in oral arguments, they suggested that the treatment team could have slid notes under the door of everyone on that floor, or they could have just told the building superintendent and let them deal with it. I have a number of questions and concerns with that. All right, so oral arguments happened just about a year ago, last October. Justices Wecht and Donahue were recused for various and sundry, sort of routine procedural conflicts of interest types of issues. In addition to the arguments about, hey, just slide notes under the door, the justices asked any number of different questions. One of the questions that rose up is, hey, what about patients' rights? Yeah, right, what about patients' rights? What about my right as a patient to keep my information, my therapeutic experience with my doctor or with my treatment team confidential and privileged? To which the plaintiff's attorney says, that's not really such a big deal. You know, the defense is saying they were doing someone a favor by protecting their confidentiality. The plaintiff's attorney then goes on to say, my sister has severe mental illness and I warn people about her all the time. Oof. Yeah, okay. So fast forward to July of this year and we get our opinion or decision. It's a 3-2 decision in favor of the plaintiff, okay? Again, if you really worry about the box score on this, it's a 3-2 with 2 recused. Justice Saylor, I believe, reaches mandatory retirement a year from now, at which point Justice Todd becomes the Chief Justice. So we'll see, right? And so they start by saying, listen, the trial court and Superior Court were right. There is a duty here, right? When there are potential targets that are readily identifiable because they are members of a specific and identified group, in this case, neighbors residing in the patient's apartment building, then there is a duty, all right? They go on to argue that the assailant had identified that he didn't like living in a personal care home anymore. He was complaining about his housing, and therefore, that it was obvious that what the real targets were the neighbors, okay? Because he'd made a threat towards neighbors, a male neighbor, a next door neighbor, again, a female neighbor who lived 5 doors down. In fact, the only known direct confrontation this person had ever had with anyone in the apartment building was when he got in a shoving match with her boyfriend to interrupt a domestic between the two of them, okay? Nonetheless, with that hindsight bias, with the surety of looking backwards, they say, look, because he kept mentioning the neighbor, look, because he kept complaining about not being in a personal care home, that it was with a moment's reflection is the language in the court's opinion, clear that the neighbors were the target, okay? They're saying that threatening to kill a neighbor is not ambiguous. And then say, look, we're gonna compare this with this other famous case from California, and we're not gonna say that, someone who's threatening someone in the neighborhood, that's too ambiguous. So we're really specific here in Pennsylvania. We're only concerned if it, right? Like to distinguish between a neighbor versus someone in the neighborhood and to hang their hat on that is to me a little bit tough to get my head around, right? Okay. So what kind of groups? This is the language they use, right? Potential targets are not the large amorphous group of the public in general, okay? So you don't have to warn the public at large. But if it's a group, and again, if you can't identify the individual person in the chemistry class, but you know that it's a smaller, finite, and relatively homogeneous group, united by common circumstance, then there's a duty. And then they have more sort of vague, waffly language where they say, all the Hampshire Hall tenants, particularly those who were on the same floor. So again, is it the floor? Is it the whole building? Again, it's really kind of hard to know, right? And again, it anchors back into some of our mistakes that warning is actually protective in some way, shape, or form. The majority opinion goes on to do a couple other things that I still struggle with, right? They say, hey, look, back in Emerich, we talked about the ethics standards of the State Board of Psychology. Now, in the Emerich case, a psychologist was one of the targets of the lawsuit. The treating clinician was an LPC. They were under the State Board of Psychology. In the Maas case, the named defendant was Dr. Barwell, who's a psychiatrist, and the CTT program. There's nothing in the regulations then or now that says a psychologist has to be part of a CTT program. There was no psychologist who would be licensed or regulated under the State Board of Psychology on that team. And yet our state Supreme Court is still anchoring their decision to the standard of ethics for the State Board of Psychology. Now let's be clear. Some of my best friends are psychologists, right? And I like them, and I'm sure their Board of Ethics and their standard of ethics is just dandy. But as a psychiatrist, I bristle a little bit at the suggestion that I'm bound and beholden to their standards. I'm also a little concerned about how many other professions' codes of ethics I need to suddenly learn, right? They go back to this idea that Emerich brings, that the duty to warn is this sort of narrow duty that's subsumed under this broader duty to protect. And they sort of say, you are so lucky, mental health professionals, you don't have to protect, you just have to warn, right? Really, I think when you break it out, sometimes these are overlapping concepts, sometimes they're not, sometimes it's easier to warn, sometimes it's easier to protect. Sometimes warning doesn't make anyone safer, right? The person goes in and tells the therapist, you know, this guy, he slept with my girlfriend and I'm gonna kill him as soon as he gets out of ACJ. All right, so now we go down and warn the 800 or 900, I guess maybe the 600 or 700 guys at ACJ and say, hey, when you get out, just so you know, Jack may want to kill you. I'm not sure that adds a lot of protection to anything or anyone. And then of course they go on and they basically, they ignore their own, they ignore precedent, they ignore these other cases and language in all of these cases that really explicitly dunks on the whole idea that we should be warning broad groups of people. Baer's dissent, or I should say Baer's dissent, which I find reassuring because I sort of get that he got the right arguments. Again, he talks about the idea that, gosh, neighbor, especially in an urban setting where there's apartment buildings next to apartment buildings, it's not that specific, right? It could mean a lot of different things. And at one point says, if each ideation of a mental health patient is broadcast to a large segment of society, that patient would be ostracized from the very community that he or she seeks to join, and the bond of trust between patient and mental health professional would be broken, right? It's a really important concept. And as frustrated as I am with the majority opinion, I am reassured that Justice Baer seemed to get what we were hoping for. Now, here's what I really struggle with, right? So it's enough that we've expanded from warning individuals and readily identifiable individuals, and now we actually have to warn members of finite, homogeneous, specific groups of people where someone in that group might be at risk, and we just don't know which one of the people in the chemistry class might be at risk. The court never said that they were going to address what specific and immediate means, okay? Yet, throughout the court's opinion, they implied that the only issue left to resolve in this case is that group inclusion, that there really isn't even a question about how specific and immediate the threat was. The fact that the person had made it over and over again, and by the way, recanted over and over again, and by the way, had not acted on those threats over 4 months. They said, well, clearly, and I would argue with hindsight bias, clearly that was evidence of that specific and immediate threat. I define those terms a little bit differently. So what does that mean going forward? We don't know, and there's a lot of different ways it could be argued out in the context of, whatever cases might be argued. So a plaintiff might say, hey, listen, the Maas decision talks about this idea of a moment's reflection to reveal the specificity of the threat. Therefore, it means what it means, right? It's this redefinition fallacy, this false equivocation. It's almost like this gaslighting, you thought you knew what specific and immediate is? No, you got to listen to us because we're in power, and that's what it really means. And again, I really bristle at that. Maybe the defense counter argument might be, hey, listen, the court only said they were going to look at the issue on the identifiability element. The Emerich S&I standard, it remains unchanged. It's sort of that, think of it as the Wizard of Oz defense, do not pay attention to the dicta behind the curtain. Or the other argument would be, gosh, whether or not they intended to do, whether or not it was an intentional move on the Supreme Court's part, they made a false equivocation, right? By implying that the facts met that specific and immediate standard, that issue needs to be re-argued if it comes up again at trial, which is sort of the mulligan. Let's do a do-over. Now, here's what my guess is. The fact that the Supreme Court used the language of a moment's reflection is noteworthy because it appears briefly one time in the Tarasoff opinion, and seldom, if ever, in any of the other canon of cases out there on duties to third parties. It does, however, feature prominently the arguments of another case that's coming up to the state Supreme Court, where the plaintiffs have argued that a physician is liable because for a moment's reflection, they considered 302ing someone, and therefore the whole cascade of events falls under the umbrella of the Mental Health Procedures Act negligence or gross negligence standards, whereas otherwise there wouldn't have been a duty, all right? And again, just like I routinely document things like denies HI, usually hopefully with a little more detail than denies HI. I also routinely, as a psychiatrist, especially as an emergency psychiatrist, in the back of my mind and usually in my documentation and saying, hey, look, I've assessed Ms. Smith, and I don't think she needs to be admitted. I certainly don't think she needs to be 302'd. So, right, and the argument of this other plaintiff, they're saying, gosh, that moment's reflection is enough to say, I'm now beholden to the rest of the standards of the Mental Health Procedures Act, which again, I'd suggest is not what the MHP is about. I may be back up here in a few months talking about that case as well. All right, but I worry that the moment's reflection language that the court used is foreshadowing another unfriendly opinion. All right, so to summarize, who do we warn? Specifically identified individual. I'm gonna kill, you know, John Smith in the chemistry class. A readily identifiable individual. Johnny in my chemistry class who knocked over my test tube. Or an entire homogeneous group when one or more members may be at risk, but we can't specifically pin them out. I'm gonna kill someone in my chemistry 201 class, all right? What's the threshold? A specific and immediate threat, whatever that's supposed to be now. Serious bodily harm sort of remains unchanged. We're talking about really hurting or killing people. It's not, I'm gonna make them feel bad. It's not that I'm gonna flick their ear. It's, I'm gonna really hurt them, okay? How we convey the warning gets really tricky, right? We had a case not too long ago at Rozel where someone wanted to kill like Joseph Roberts or Robert Stevens or some really non-specific name in Georgia. And I like went to whitepages.com and they're like, yeah, there are like 79 people with that name in Georgia, right? Really tricky to figure that out. So what do, right? We consult. Let's talk about that. Tom Gutile, very famous forensic psychiatrist, says never worry alone. Okay, it's sort of one of the mantras in forensic psychiatry. And I think it should be one of our mantras in clinical psychiatry. If we have a case we're struggling with, if we're unsure, if there's risk, we reach out, we call a friend, right? And that can be getting a psychiatric second opinion in a clinical setting if the treatment team is not a psychiatrist. It can mean getting another psychiatrist to come in if we're already a psychiatrist. It means engaging leadership, right? So call the boss, call the supervisor, call our legal team, call our risk management. I think one of the things that always sort of frustrates me in healthcare is we think of our risk managers like they're the cleaners, like something bad happens and they come in and they do the RCA and help us do the paperwork with the county. We should be calling them as soon as we've reached that point of worrying, okay? And say, hey, I've got a really tricky case, I'm not sure what to do. Because the memory that our risk managers have, the experience that they have is phenomenal and they can help walk us through some really delicate situations. And I know they like to be contacted early and not late, okay? Within UPMC, we have something called the System-Wide Threat Assessment and Response Team. We've got a phone number that's a point of access. We've got an email that's a point of access. This is for UPMC folks only. We have a number of people logged in that are from outside of UPMC. So, you know, consult your local resources. And this is what I'll say. And by the way, this is what I will say as the president of the American Association for Emergency Psychiatry. There is no shame in admission, right? If we've got a case in the DEC, if we've got a case in our PES, or on the CL service, I'm thinking, I think a lot of this is just personality stuff. I don't think this is necessarily something I'd normally admit, but there's enough to this threat that I don't know. And I don't want to let them out into the community until I know more, to bring them in for a couple days, the chance to get a better assessment, to flesh out more about who the target might be. I think that's not a bad idea. To do it once, maybe even twice, to create one of those really nice discharge summaries that sort of talks about, hey, these are the risk factors, this is what's driving it, this is what we've done. To have that really nice documented tool that helps us make a better decision next time, right? And that documentation really helps, right? Passing on the information from treatment encounter to treatment encounter makes a world of difference. And having that clear documentation really helps us out, because one of the rubrics of sort of med-mal, right? I always say it's kind of like high school math. Even if you get the wrong answer, if you've shown your work, you're going to get partial credit. And that's part of the process we can do with that second opinion or you know, that further formulation. And maybe, just maybe within UPMC, we're developing a warning advisory and response team that's sort of, you know, in the pipeline that they're working on. Okay, some things to think about in your documentation, right? So I've got the scary case, I'm not sure what to do. So what have I done to figure out the identity of the target, right? I said, okay, Ms. Smith, you know, would you like to tell me who it is at, you know, HCJ that you're really mad with? Nope, don't want to. Okay, ask, and they refuse to give me more specific information, right? Or what did we learn, or what did we try to do to flesh out who it is? Now, by the way, we are mental health professionals. We're not bounty hunters, right? We're not skip tracers. We're not, you know, we're not detectives. We're not trained, competent, or supposed to be going around trying to, you know, track vaguely identified folks. Frankly, that's an intelligence function, as in like Washington, D.C., national security intelligence, not like our front brain, forebrain intelligence, right? It's just a specialized skill set that we don't expect each other to have. What we've done to sort of narrow down that identity or the class, what made me believe that this was a specific and immediate threat, or what made me doubt that this was a specific or immediate threat, however you want to define that. Maybe the fact that, you know, sort of the means that they discussed was incredible, right? I want to kill the president. How? I control, you know, the QAnon satellite network, right? Okay, I'm not super concerned about that threat, right? Or they have that impersistent threat. I'm so pissed off, I'm going to go blah, 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 blah. And then like 5 minutes later, they've de-escalated and calmed down. I didn't really mean that. Or at the time, yeah, I really meant it, but not right now, right? So it's not a persistent threat. Who was consulted? I called Jamie, I called Ken, I called Keith, right? All these other people sort of, you know, reviewed the case, maybe laid eyes on as well. They thought it was a good idea or a bad idea. Now, by the way, I'm not going to write, I discussed it with a litigation manager. I'm not going to write that I discussed it with Shaitan, one of our attorneys, because those might be privileged communications. Now, by the way, Shaitan might say, yeah, you can actually document you discussed it with me, but generally we're going to want to keep that privileged communication, you know, out of the medical record, okay? And by the way, if we did warn, who did we warn? How did we warn them? And, you know, how were they told? I'm hoping we didn't do it by slipping notes under people's doors. But who knows, right? Do we have Warden Harper get on the squawk down at ACJ and say, hey, for all of our male inmates on release, you may be in danger. Jack Rozel may want to kill you, but we're not sure which one of you. Good luck with that. Ugh, right? Again, there could be some repercussions. All right. A question that has cropped up a lot recently. Does warning or notifying the police make a difference, right? So I've made a threat to someone, and we don't really know who, but, you know, someone over in like McKees Rocks. I'm going to get Joey in McKees Rocks. We don't really know who that is. Do we call the McKees Rocks PD and say, hey, guess what? Jack made this threat. We don't really know what it's about. Or do we just say, hey, you know, he's this person. We can't reach that person, but we're just going to, you know, hand this off to the police. Or do we just do it as a matter of routine, right? Well, when we go back to sort of our case canon, and Tarasoff 1, the court actually threw out the idea, because the treatment team said, hey, listen, we handed this off to the police. They let him go. It's not a responsibility. The court said, you're still on the hook. And they sort of said the same thing in Tarasoff 2. But in Tarasoff 2, they said, you know what? It's a duty to protect. You may be able to call or warn the victim. You may be able to call the police, but you've got to protect. And if you think engaging the police will be protective, then that's fine. In Emerich, in a footnote, they actually said, you know what? The whole issue of whether or not you notify the police, it's not relevant. They said it's dicta. They actually correctly tagged it as dicta. In Maas, the majority cites the right Tarasoff language. And the dissent, they don't really talk about the issue at all, but this is what's significant. Justice Baer in the oral arguments, and a lot of people sort of said, ooh, we're paying a lot of attention to this because it did come up in oral arguments. He says, why wouldn't there be a duty to call the police? In circumstances where there's no ascertainable victim, just call the police. And then he says, you might prevail in this case, but we might write that in for a future duty, okay? And they ended up not, but boy, he sort of, you know, threw this grenade out there. Now people are really anchored to it. Well, here's the thing. There's also a really important Supreme Court case called Castle Rock v. Gonzalez. It came out just a few years ago. In this case, a couple had divorced. There were kids involved. And the guy takes the kids without permission at an unscheduled time. There was a PFA in place. And the woman called the police repeatedly, I think 3 times over the course of the evening, says, you took the kids. I'm worried about their safety. Please find him. And 3 times the police ignored it, until the guy comes in armed, opens fire in the police station, at which point they shoot and kill him. They then go out to the parking lot and find the car with the dead children. All right? Police force notified repeatedly the children may be in danger. And what the Supreme Court said is that the police actually had no duty to protect even when they were aware of the threat and the risk. So knowing that that's out there from the US Supreme Court, I think the idea of saying, hey, if we punt this issue off to law enforcement, that's gonna do something meaningful, I don't think that's very realistic, okay? Now, they may have the capacity to intervene. They may be able to add some protection for that target. It may be part of a broader strategy of protection, but as a sole intervention, as a routine intervention, I don't think so, and certainly not as a standard of care, okay? All right, so again, threats are one dot. We've got to collect the dots before we can connect the dots, but threats are only one dot. They are neither necessary nor sufficient in and of themselves. All right, but the courts focus intensely on threats. And at the end of the day, it's always going to be risk versus risk. And as medical director of Resolve, if I have a choice between potentially, ending up writing a check downstream because we breached confidentiality, or potentially writing a check because we didn't breach confidentiality and someone got really hurt or killed, at the end of the day, that might actually be one of the easier decisions that comes to my desk. It's always risk versus risk. And what I'll say as we close, the risks are not always knowable. The risks are not always comparable. We work in sort of the deep end here. We're in an environment surrounded by risk. We shouldn't pretend that it's not there. But at some level, we're talking about managing fear or managing danger. We're deciding between that lawsuit for a breach of confidentiality or a lawsuit for a failure to warn or protect. The future is uncertain, the present is complex, and the past tainted with hindsight bias. That's what I got for you.